Programme motion. Move formally.
I beg to move.
Question is, as on the order paper. As many of that opinion say aye?
Aye.
Contrary, no? Ayes have it. The clerk will now proceed to read the orders of the day.
Digital Markets, Competition and Consumers Bill, consideration of Lord's amendments.
Now.
I must first draw the House's attention to the fact that financial privilege is engaged by Lord's Amendments 35, 36, 42, 112, 117, 128 and 132 through to 134. If those Lord's Amendments are agreed to, I will cause the customary entry waiving Commons financial privilege to be entered in the Journal. We begin with Government motion to disagree with Lord's Amendment 9, with which we will consider all of the other motions on Lord Amendments as on the order paper. Minister to move the motion to disagree with Lord's Amendment 9. Minister.
Thank you, Mr Deputy Speaker. And it's a pleasure to bring this groundbreaking bill back to the House. This bill will derive innovation and deliver better outcomes for consumers across the UK by addressing barriers to competition in digital markets and tackling consumer rip-offs. We believe it strikes the right balance between not deterring investment from big tech whilst encouraging investment from challenger tech. I'd like to thank members of both Houses for their careful scrutiny, and I commend the collaborative cross-party approach taken during the bill's passage to date. I will start by speaking to the amendments that the Government made in the other place. These amendments add vital new provisions to the bill, and I hope honourable members will agree to them. Part 1 of the bill establishes a new pro-competition regime for digital markets. The regime will be overseen and enforced by the Competition and Market Authority's Digital Markets Unit. Following engagement with members in the other place, we have bolstered transparency provisions to require the CMA to publish more of the notices provided to firms designated with strategic market status, or SMS. All interested parties will now be able to access information contained in these notices. This ensures that there is greater clarity when it comes to the DMU's decisions relating to SMS designation, conduct requirements and pro-competition interventions. A number of honourable members would call for provisions addressing asymmetry of information to be introduced to the bill. Therefore, we hope this change will be welcomed. On Part 2 of the bill, which deals with wider competition reforms, honourable members will recall that the Government added a provision at report stage on litigation funding. Its purpose was to restore the previously held understanding of the status of litigation funding agreements under the Competition Act 1998. These provisions were so important they provide a route to justice for groups with limited resources, for example, our sub-postmasters. This step was taken in response to an earlier Supreme Court judgment which had made litigation funding agreements unenforceable. The Government has since acted and introduced the Litigation Funding Agreements Enforceability Bill. That bill will deliver on our commitment to address the impacts of this judgment in all types of proceedings. Consequently, the provisions in this bill have been removed as they are no longer required. We also introduced new measures to Part 2 to address concerns about the potential ownership of UK newspapers and news magazines by foreign states, as you heard very recently from the Secretary of State. The Government knows that we cannot overstate the importance of these publications to our democracy. We therefore taken decisive action to preserve the freedom of the press. By establishing a new regime within the Enterprise Act 2002, the bill will prevent foreign states having ownership, control or influence over a UK newspaper or news magazine. The Government is extremely grateful for the support offered by members of both Houses in the development of these new measures. In particular, we would like to thank Baroness Stowell of Beeston and Lord Forsyth of Drumlene for their engagement, and also my honourable friend, the member for Rutland and Malton, who first secured debate on this issue in January. Parts 3 and 4 of the bill make important updates and improvements to UK consumer law. Having consulted on a series of reforms at the end of last year, the Government amended the bill in the other place to introduce new measures addressing fake reviews and drip pricing. Many honourable members previously called for the Government to address these harms through this bill, and pleased to say we've been able to do so following our public consultation. We've also made amendments to further strengthen the ability of public bodies to enforce consumer law. We did this by extending so-called take-down powers to a wider range of enforcers. There's also been a healthy debate in both houses about the measures in the bill aimed at tackling subscription traps. We listened carefully to the concerns expressed in the other place about the potential impact of these measures on charities and their ability to claim gift aid. In response, the Government amended the bill to enable the Treasury to update gift aid rules. This has mitigated any concerns about the bill's impact on charities. We are grateful to Lord Mendoza for highlighting this issue and for his engagement. We also made a series of amendments to provide greater assurance and clarity for businesses in relation to the new subscription measures. This includes addressing concerns around exiting contracts, cancellations, reminder notices and cooling off periods. And I hope honourable members agree that these amendments improve the bill. Yes, very happy to give way.
I'm grateful to the Minister for giving way. The Liberal Democrats are welcoming the fact the Government is finally acting on the CMA's recommendation, but I would like to ask if the Government will support Amendment 104, which is backed by the Liberal Democrats, and it's about imposing requirements on secondary ticket sites. And often people purchasing tickets from these sites do so at huge markups on the face value of the ticket, and often the ticket in question doesn't actually exist. And this amendment would address these issues, reducing the risk of fraud through requiring proof of purchase. So would the Minister agree with me that we must do everything we can to ensure this legislation is robust as possible to crack down on this type of fraud?
Well, I can thank her for her intervention and the amendment, which I'll speak to in a second. What the Government's agreed to do is undertake a review of both primary and secondary markets, but I will deal with those further in my remarks as I go along. And certainly that's something, again, I hear from the shadow front bench, but that's something Labour were proposing in earlier amendments, I think. So obviously they've changed their position on that particular issue. Not for the first time. Finally, the Government made a number of minor amendments to the bill in the other place. The majority of these are tidying up measures or otherwise small tweaks to the bill to ensure it achieves its policy intent as effectively as possible. I'll now set out the Government's position on the 11 non-government amendments that were made to the bill in the other place. The majority of these amendments seek to reverse or alter amendments made to the digital markets part of the bill at report stage in this House. There were three aims behind the Government's package of amendments at Commons report. The first was to provide greater clarity to parties interacting with the regime. The second was to strengthen the regime's safeguards for the extensive new regulatory powers. And the third was to enhance the accountability of the regulator. The Government brought forward this package following careful consideration of the views expressed by honourable members across the House. We remain convinced that our amendments struck the right balance. That is, between accountability of the CMA's regulatory decisions and the flexibility to allow for targeted and proportionate action to tackle the unique competition challenges in digital markets. Very happy to give way.
I'm very grateful to my honourable friend. He's quite right that the amendments that were agreed at report stage in this House struck the right balance. I'm afraid on this occasion I wholly disagree with their lordships and their characterisation in their debates about what was happening here. We're not arguing for a wholesale replication of the telecoms regime. We're simply making sure that there is, particularly with regard to penalties, which will be pretty onerous and rightly so, that there is a proper discretion to allow a reviewing tribunal and a reviewing court to consider the matter carefully in a way that I think balances out the need for there to be rigour but also some temper when it comes to the power of the regulator.
Well, can I thank him for his intervention and for his earlier engagement. We made that his position very clearly on this particular point. He's right to say the penalties can be significant, 10% of global turnover up to some of the penalties. So making those an ability for an organisation to challenge those on the merits, I think is a fair point, whilst maintaining the position that the pro-competition interventions or the conduct requirements can still be imposed on those platforms. The amendments made in the other place would risk undermining that careful balance. For example, amendments to revert the appeal standard for fines to judicial review principles, as my right honourable friend referred to, would remove a valuable safeguard on the significant new powers this bill gives the CMA, as would the removal of the requirements on the CMA to act proportionately. Meanwhile, amendments to the countervailing benefits exemption would risk making the exemption less clear for stakeholders. To that end, the Government is tabling a motion today to disagree with those amendments. Happy to give way.
That's wonderful. With regards to the relevance of the point about proportionate response, because in the original drafting of the bill, it was appropriate. The Government changed it at report stage here to proportionate, and the Lords have sought to reverse that. Now, can he say what does he believe it was about the appropriate measure, which was disproportionate, if you like, that struck the wrong balance? Because ministers keep saying they think it strikes the right balance, but they never really explain why.
Well, I can thank him for his point. I mean, we engaged significantly throughout the course of this bill and before it was introduced with large tech, of course, and challenger tech. And it's our position and our understanding that all those cohorts are happy where the bill is today. But certainly in the engagement and concerns were raised about appropriate. And but our position always back to those people who raised concerns about that was, well, of course, there's a requirement for the CMA to act proportionately. That was our clear position. Putting that, therefore, on the face of the bill, to us, it's not something that undermines the basic principles of this bill. In fact, very much so, we understand from the basic situation in the European Court of Human Rights and the property rights that emanate from that, all those things are baked in anyway. So we don't feel this weakens this legislation at all, but does strike the right balance between those two different cohorts. Yeah, happy to give way, of course.
Extremely grateful to him for giving way. And on the same point, because it's clearly important that we understand what proportionate means in this context, is it the government's position that proportionality implies there is more to think about than just how effective the intervention is as a conduct requirement to fulfil its own objectives? And if that's the case, is there something the government can do to make that clear? Because otherwise we shall expect, should we not, that the courts and tribunals which consider these cases will fill the gaps themselves. And the word appropriate could be drawn quite widely if the government isn't clear about what it means about proportionality and appropriateness.
Well, he will know from his legal background that the term proportionate is a well-established principle in law. And of course the courts play an important part here. We don't prescribe everything in our legislation. Of course there is opportunities for people to challenge certain decisions by the CMA, quite rightly. Clearly we're trying to reduce the ability for a large tech to be able to prevent the investment from smaller tech. Clearly that's a balance we are striking here. But we do not want to discourage investment from that big tech. So I think the requirement of the CMA to act proportionally is a reasonable one. I think my right friend also wanted to intervene.
I'm grateful. He did suggest that stakeholders were now satisfied with the bill. I can tell him on this particular point there is concern, and it is around this change of the wording from appropriate to proportionate, because the fear is that this will actually allow the courts to look more broadly and allow more scope for challenges than had originally been intended when the word was appropriate. Can he confirm that that is not the government's intention?
Well, no, it's not our intention. Intention is to strike a balance. And I said earlier, the court's approach to proportionality was set out by the Supreme Court in the Bank Mail Act against the Treasury No. 2 case, when the court described the elements to be considered, including most notably whether a less intrusive measure could be used and whether there's a fair balance between the intended objective for the measure and the effects on the business and the measure applies to. I think these are sensible requirements, a sensible position that we strike. Of course, some stakeholders want to go further in certain directions, others don't want you to go as far. What we're trying to do is strike that balance. We welcome the investment in big tech in the UK, but we also welcome investment by challenger tech, and this bill is a groundbreaking bill, and it's the only one of its kind in the world that deals with it in this way. We think we are striking that balance. We've also listened carefully to arguments put forward relating to the Secretary of State's approval of CMA guidance. Amendment 38 tabled by Lord Lansley, adds a timeline for the Secretary of State to approve CMA guidance relating to the new regime. In response, we are bringing forward Amendment 38A, which achieves a similar effect. The amendment proposes a statutory 30 working day timeline for the Secretary of State to approve the necessary guidance. We believe this addresses concerns about the ability of the digital markets regime to start tackling competition problems without delay, and we hope honourable members will support the amendment. Secondary ticketing. Finally, there was one non-government amendment, which the Honourable Lady referred to, made in the other place to the consumer part of the bill on secondary ticketing. Amendment 104, tabled by Lord Moynihan, seeks to introduce additional regulatory requirements on ticket resale sites. These requirements would cover proof of purchase, ticket limits, and the visibility of certain required information, such as the face value of a ticket. Both Lord Moynihan and the Honourable Member for Washington and Sunderland West have spoken passionately on this topic during proceedings on this bill. We are hugely grateful for their work to highlight the malpractice in the resale market. To be clear, the Government is absolutely committed to protecting consumers from fraudulent activity in the secondary ticketing market. However, it's our view that protections for consumers are already provided for by existing consumer law. The law imposes specific information requirements in relation to secondary ticketing which go above and beyond general consumer law. This includes requiring all resellers, be they traders or consumers, and the secondary ticketing platforms to inform a buyer about the face value of the ticket and the restrictions as to its use. The Government's position, therefore, is that the secondary ticketing market is already suitably regulated. That said, the Government recognises the strength of feeling on this matter expressed by members of the other place and in certain quarters of this House. Therefore, we are making a commitment today to undertake a review into ticketing practices and how they impact consumers. This review will look at both primary and secondary markets, in other words, sellers and resellers. We believe it is important to consider both markets together. Very happy to give way to the Honourable Lady.
I'm very grateful for the Minister giving way, and I know we've debated this point before, but I will come to it further in my contribution in time. But just to make the point again that there may be legislation, but it's not working. There's only been 2 prosecutions in all this time since 2015 with the Consumer Rights Act. And I just want to ask him the question, if further legislation wasn't needed, why did we bring in legislation to protect the Olympic tickets?
Well, it's not right to say there's only been 2 prosecutions. There have 2. No, if I can just finish. There's 2 that have been sentenced. There's 2. I think 2 people got a £6.1 million fine. 4 more successful prosecutions in Leeds Crown Court only very recently, and sentencing is due to be imposed on those individuals. So she raises some very important points, which we'll always listen to, and she does some great work on the all-party group. So we are undertaking this review, which will look at primary and secondary markets. It will be every chance to be able to input into that review, of course, just as anybody else will. So we'll look forward to hearing her representations. I think the Honourable Lady wants to make an observation as well.
Yes, she does, and I'll say more later, but thank you, Minister, for giving way. But the Government claiming that it's doing enough, it's just not the case. Here's an example. If the Minister looks on a secondary ticketing site and sees 3 tickets together for Taylor Swift's show on 21st of June, going for £72,000, tickets that had a face value of £170 each, how is this market working?
Well, I agree some of those examples are clearly shocking. The key is what measures are you going to put in place to address it? Now, in Ireland, for example, they completely banned secondary sales, and yet the prices shown on the internet are equivalent level as what she's just described. So there is no perfect solution here for what's been already tried, but we're very happy to look at the evidence, look at what might be done and do something that's effective rather than something that is crowd-pleasing, do something that is effective, and that's what we're committed to do. The reality is some organisers are simply much more successful at preventing large-scale unauthorised resales than others. The ticket market is clearly evolving rapidly. Our review will therefore consider evidence both from businesses and platforms operating in both markets, as well as venues, artists, enforcers and consumers. The Government intends the review to take place over 9 months, after which the Government will consider any appropriate further action. I very much hope, honourable members, I would say to beware of overconfidence from that comment from a secondary position. I very much hope honourable members will support our position today. I especially hope that members in both houses will note the government's movement in two important areas: on the Secretary of State's approval of CMA guidance for the new digital markets regime and on secondary ticketing. These changes are considered and balanced. I urge members in the other place to consider their position on the other amendments that our motion seeks to reject today. Throughout the bill's passage, the Government has listened carefully to the arguments presented. In response, we have made a series of significant changes where we have recognised that improvements could be made. It is important now that we reach full consensus on the bill's final form so that it reaches the statute book without further delay.
Yay. Question is that the Lords disagrees with their Amendment 9. Sir Chris Bryant.
Mr Deputy Speaker, first of all, might I pay tribute to my honourable friend, my neighbour, my much-loved neighbour for Pontypridd, who did the last round of this for our front bench, and also to my honourable friend, the member for Feltham and Heston, who was leading for us when the bill started. If I might just say a few words about the Minister first. I do love the Minister. He has that... members sitting at the back benches will not have been able to see the kind of little wry smile that was playing across his face as he was saying, as he was making his speech. Unfortunately, Hansard isn't able to record that element of the way he presented his case. I'm going to let the House into a secret. There are two versions of the Minister, or rather of the member, because there's the backbench member, who I passionately agree with on nearly everything. And then there's the government minister member, who has the backbench member sitting inside him, I think, somewhere, but has managed to lose him in the process of corporate and shared responsibility on the government benches. I would bet that if he is in the Parliament after the next general election, and we were to be debating these matters all over again, he would almost word for word be articulating what I'm about to say. But I note that today he has articulated the government position. Of course, I give way to another gentleman for whom I have a great deal of respect and occasionally disagree.
Thank you, Mr Deputy Speaker. I just wonder whether the transformation that occurs, which he has described when somebody moves from the back benches to the front bench, applies equally on the opposition as it does on the government.
Well, and he should know more about bobbing between the backbench and the front bench than most other members in Parliament in history, I think. Well, it is obviously a problem, and it is a keen... I do believe in shared responsibility of government. You want government to act as a single body and not irresponsibly. So I understand, but nonetheless, it's perfectly appropriate to tease the Minister when he's got such a wry smile on his own lips. Mr Deputy Speaker, this bill is a classic instance of how the Tory chaos that we've seen over the last few years has been bad for Britain. It is long overdue, as the Minister himself said. It started in the Commons more than a year ago, on the 25th of April 2023, and in fact it is so delayed that the carryover motion had to be carried over, something I can't remember happening for many, many years. They had to do that last week. The bill used to strike the right balance between different parts of the market. But the member who just spoke is absolutely right to say that many stakeholders are certainly not happy with where the government has landed now, because intense lobbying of Downing Street from some parts of the market has led to the government tabling amendments which would fatally undermine the very purpose of the bill and make it impossible for the CMA to do the job that we wanted to do, namely ensure fair competition in digital markets in the interests of consumers, investors and wider society. Let me remind members of what the Right Honourable Member for Swindon South said. It's good to see him in his place. This is a market that is vulnerable and some would say prone to monopolistic abuse of market power. And what the Minister himself said at the first second reading debate on the 17th of May last year. Competition must work hand in hand with consumer protections. Spot on. So why ruin the bill? Because this is the nub of the matter. The member for Meriden said in the report stage debate that a small number of firms exert immense control across strategically critical services online because the unique characteristics of digital markets, such as network effects and data consolidation, make them prone to tip in favour of a few firms. He's absolutely right. But what the government is doing today helps tip the legislation back in favour of those few firms and is a mistake. They pretend otherwise. The Minister has said the amendments won't make any difference. But in which case, why table them? In an attempt to save the government from itself, the Lords have tried to return the bill to its original shape with 4 sets of amendments, which I will now go through. Firstly, on proportionality, namely Lords' Amendment 9 and Amendment 19. The original government version said that the CMA's conduct in regulating digital markets had to be appropriate. The government, then changed that to proportionate. The Lords' Amendment would put it back to appropriate. The government version, I believe, would in effect render any challenge to the CMA's conduct a test of the merits rather than a judicial review, and will provide big tech firms with limitless legal budgets even more scope to tie the CMA up in lengthy legal wrangling. Jarndyce and Jarndyce in the Court of Chancery would have nothing on the CMA in the High Court. The government seems to be deliberately clipping the wings of the CMA, and we agree with their lordships that the bill should be returned to its original form in this area. Of course, I give way.
Grateful to him for giving way. How would a tribunal consider the appropriateness of a CMA intervention without considering the detail of it?
Not quite.
And the merit?
Well, the point is that either the change is necessary because it is a new and a different measure that is being adopted by the government, in which case I would argue that it is a lower threshold and therefore inappropriate, or it is making no difference whatsoever, in which case it is unnecessary. So by the normal standards of deciding whether an amendment is appropriate, we would be saying either is it necessary or does it provide a good remedy. I think it does neither, and that's why we don't support the government amendment. Secondly, countervailing benefits, Lords' Amendments 12 and 13. The countervailing benefits exemption, and just to prove that members speaking from this dispatch box are very consistent with one another. The next sentence was effectively written by my honourable friend from Pontypridd when she spoke in a previous debate. The countervailing benefits exemption allows the Competition and Markets Authority to close an investigation of a breach of a conduct requirement if a firm can demonstrate that its anti-competitive conduct produces benefits that outweigh the harm and are therefore indispensable. At report stage in the Commons, the government significantly reduced the threshold for the exemption, removing the word indispensable and merely requiring that those benefits could not be realised without the conduct. Yep. It sounds the same, but it's different, subtly and, I would argue, importantly different. The Lords' Amendment would mean that the phrase would remove that subclause and alter the next line so that it reads, the conduct is indispensable and proportionate to the realisation of those benefits. I would make 2 points. Firstly, the indispensable standard, as I think everybody accepts, is a well-understood concept in UK competition law and is indeed used in the Competition Act of 1998, which I do not believe to be as outmoded as some others have suggested. Secondly, the courts would interpret Parliament's deliberate move away from an existing well-understood standard as intended to create a new, lower threshold. This will, again, inevitably allow the big tech firms greater scope to launch complex legal challenges. If the government really doesn't see any distinction between the two thresholds, the most obvious compromise would be to reinstate indispensable alongside its new wording and clarify, today at the dispatch box and in the bill's explanatory notes, that the indispensable standard and the new form of words inserted by the government have an identical meaning. Otherwise, there is a risk that the courts will seek to explore further whether Parliament has deliberately created a new threshold and a new standard. And I would simply say to the Minister that I remember when we were having lengthy discussions about the powers of Companies House when he was on the backbenches, he was very keen on making sure that Companies House had the powers that it needed to be able to do proper investigations, because he regularly made the point that lots of people have very deep legal pockets, and that does not necessarily mean that the consumer always wins out. And that, I would argue, is the same case here. On appeals, Mr Deputy Speaker, these are Lord's Amendments 26, 27 and 28 to Clause 289 and Amendments 31 and 32 to Clause 103. The bill originally had judicial review as the appeal standard for all CMA decisions under Part 1. But in the Commons, the government moved to merits appeals for penalty decisions, and I accept that this is only about penalties decisions. I nonetheless believe that this is dangerous because, whilst the new regime is intended to be collaborative, it is ultimately the threat of fines that will incentivise big tech firms to comply with the CMA's decisions. If there's no prospect of a fine, whether large or small, it may well be that those large tech firms would decide to be less collaborative. There is an even greater danger that merits appeals on penalty decisions bleed back across the bill into regulatory decisions, giving big tech firms greater scope to frustrate and challenge the CMA decisions. Whilst it is correct that the courts are generally able to distinguish between judicial review and merits elements of appeals, a point that has been made in previous debates by the member, the former Attorney General, it does not eliminate the concern about the two bleeding into each other, especially if the two streams take place together in the same case. If the government is unable to reinstate judicial review appeals across Part 1, as we would prefer, a clarificatory amendment should be inserted into the bill, providing certainty that appeals on penalties cannot impact other regulatory decisions to eliminate scope for speculative challenges. And it is worth bearing in mind that the Chief Executive of the CMA made it clear that the authority wants the JR standard to apply. She welcomed effective judicial scrutiny of their decisions, but said, "We think that the judicial review standard achieves that." She went on to say that her experience of merits appeals was that they result in very protracted litigation, making it a lot harder to reach constructive, collaborative outcomes because all eyes are on that litigation process. Mr Deputy Speaker, let me come to the matter of ticket touting and Lord's Amendment 104. And let me start, first of all, by thanking Lord Moynihan, for a Conservative peer, of course, for tabling this amendment and for the very significant work across many, many years. I feel sometimes that when I've not agreed with every sentence that my honourable friend for Washington and Sunderland and West has come up with on this subject, I have felt the scratches on my back from her very elegant fingernails. But she has done enormous work, and I think she is much to be praised for it. And there are many others in the House for whom that is true as well, including all those who are sitting next to her on the back row, who I'm sure will catch your eye in a moment. I start from a very simple principle. The value of a ticket, whether for the rugby, the football, or for a gig at the O2, is created by the artists, by the promoters, and above all by the fans. Yes, the secondary ticketing market can help all three. Sometimes you buy more tickets than you need, or you're unable to attend for whatever set of reasons. But its abuse, the abuse of the secondary market, can lead artists, promoters, and fans can lead them all losing out. And abuse is rife. I will take an example of a case that has already been through the courts, that of Linda Chenery, Mark Woods, Maria Chenery Woods and Paul Douglas, who bought and resold concert tickets worth £6.5 million. They bought them on primary sites, including Ticketmaster, before reselling them on secondary ticketing platforms at inflated prices such as Viagogo. They used endless tricks, sending customers ripped envelopes to infer that the tickets had been lost in transit, or using fraud juice, which involved the use of Tipex correcting fluid, or more sophisticated digital methods to amend tickets. They held their customers in open derision, having scammed one person into paying £535 for a ticket for the Harry Potter West End show. They referred to him in an email as another idiot. These people are despicable parasites preying on fans, and we need to go far, far further to address this issue. This prices many fans out of the market and adds no value whatsoever to the creative process at a time when creators are in desperate need of making sure that they are able to make a living out of their craft. In 2016, one ticket for Adele at the O2 Arena in London was listed on Get Me In for £24,840. That's 290 times the face value of the ticket. Nobody in the Rhondda would be able to afford such a ticket. Wimbledon, incidentally, is facing exactly the same set of problems. Viagogo are today selling 2 tickets for Pink at the Millennium Stadium in Cardiff on the 11th of June for £498 each. I think the fans could perfectly legitimately start shouting, "What about us? What about all the plans that ended in disaster?" It's not obvious even what the original price is for those tickets. Or you can get on Viagogo one ticket for Peter Kay at the O2 on the 4th of May for £302. Or the Book of Mormon, which has been in the theatre for several years now, on the 4th, and is a wonderful, hilarious show, on the 4th of May at £420 each. Or this is the one that upsets me in a way the most, The Winter's Tale, the ballet at the Royal Opera House on the 3rd of May, Friday night, for £1,006 each. You can buy those tickets from the Royal Opera House for £140, and that's because there's taxpayer involvement in supporting the Royal Opera House. You could say the same of StubHub, Doja Cat in Glasgow, standing tickets, 2 tickets for the 11th of June, face value £162, selling at £1,002. This is a pernicious industry. It is parasitical and it does nothing for the creative industries in this country, and we must tackle it. I feel the fingernails now.
I'm very grateful, and I waited till he got to the end of giving all of those disgraceful, abhorrent examples. And I just wonder if he will clarify for me a fallacy that the touts often put around about me, and it'll be around him and our friends' work on this now, that we want to stop people being able to resell their tickets when they genuinely can't go, they bought them in good faith and they can't go. Will he clarify for now that that is not what any of us seek to do? I want, of course, people to be able to resell their tickets, but at face value. Does he agree?
And that is Labour Party policy. And I'm used to fallacies being written about me, and I've seen many written about her as well. I'm sure we'll all get over it. Which is why, incidentally, as I shall come on to later, it's very important that we have a free press that are able to say what they want, free from the intervention of state owners from other countries. But she's absolutely right. Of course, it is perfectly legitimate for somebody who has bought a couple of tickets for Saturday night when they suddenly find that they're ill, or there's a family engagement that they have to go to, or whatever, or they've bought tickets for the wrong night, that they should be able to sell them on at face value, or perhaps a little bit more, simply to be able to cover the costs of administration and things like that. But this is a market that is not working. It is an example of market failure, not an example of market success, and I feel some more fingernails.
My fingernails are nothing like that one. I wonder if he agrees too that the problem is actually worse than just the prices he's quoted, and he gave some really good examples and really powerful examples, because there's the selling of tickets which don't actually exist, the fraudulent tickets. And I've heard from a number of venues that the selling of tickets that should go to carers, tickets that should go to young people, and people are turning up at events like O2 and other venues with these tickets and being turned away, often when they have travelled to London, when they have paid for hotels. So there's all the disappointment and the financial loss of that on top of the ticket prices.
Yeah.
I completely agree. She's absolutely right. There are terrible instances of all sorts of different kind of scams, and remarkably few prosecutions, is the honest truth. Whether it's 2 or 4 or 5, I mean, it should be in the hundreds, because 6, great, half a dozen. The truth is, we all know instances from our own constituencies of people who have faced precisely these problems. And sometimes, I mean, I've had constituents who said to me, I feel too embarrassed to own up to having bought these tickets, because, of course, I used to remember going past the Millennium Stadium in Cardiff or the Arms Park in the old days, and we all despised the ticket touts, just as we did outside a Kate Bush concert or whatever. But sometimes you were just so desperate that you bought the tickets, and then, of course, they turned out to be fraudulent, they turned out to be non-existent, or they were allocated to specific kinds of people which didn't include them. All those points are very severely made. And the one point I would add to this is that many local authorities have trading standards, well, they all have trading standards offices, but many of them are now so depleted because of the state of local government finances that it's really very difficult for anybody to get a proper recompense and a deal. Now, the amendment that we've got from the... I'm sorry, I wasn't sure whether the PPS was seeking to intervene, but the amendment that we've got... He's not allowed to, no. Poor thing, he's silenced. The amendment that comes from the Lords does the bare minimum. It really does. It would require facilities to only accept postings if they provide evidence of purchase from the primary market. It would limit resale of more tickets than a single customer can buy on the primary market. And it would require clear information on the face value and trader's business name and address on the first page of a secondary ticketing facility. That is simply not what you can see on any of these sites today. Now, if the Conservative Party, the government as it presently is, refuses to act, Labour will. We will bring these measures in and go further, restricting the resale of tickets at more than a small set percentage over the price the original purchaser paid for it, including fees. Fans have been waiting for far too long. A Labour government would end the pernicious and predatory ticket touting and put fans back at the heart of music, cultural and sporting events where they belong. Yeah. And if I might just say, the idea of a review... well, we've moved on, and it's about time they moved on. And in fact, I look forward to the day when he moves on from there to here. But honestly, the idea of a review in the dog end of a parliament at the end of the regime is absolutely pathetic, and I'm glad he's laughing at himself for even presenting the suggestion today. Let me end, Mr. Deputy Speaker, with an area of agreement. We were glad that the government, under pressure, tabled its Amendment 117 regarding mergers involving newspaper enterprises and foreign powers, along the lines of measures we and others, including a large number of Conservative MPs and peers, had called for. Of course, the UK must remain an open economy. We welcome foreign investment in many sectors in the UK, but we agree that in this limited area, the state ownership of UK newspaper media companies, it must be a matter for concern, which is why we support the Lord's amendment. We will need to make sure in future years that it is adequate to the situation that we find, not least bearing in mind many of the comments that were made earlier by right honourable and honourable members on both sides of the House regarding the rather fluid world we're moving into, where a newspaper is a rather outdated concept and social media and other forms of online media are far more significant. We'll have to keep that under review, but we welcome the amendment that the government has tabled. Mr. Deputy Speaker, this long-delayed bill could go forward with strong, unanimous support if the government abandoned its tilt towards the few potentially monopolistic companies and set aside its objections to the Lord's amendments. They are either completely OTOs or they are dangerous. The Minister says they make no difference. I say they do. On either grounds, they should go, and we support their lordships in their amendments.
Penrose. Thank you, Mr. Deputy Speaker. And can I start by saying that this bill was and still is a good bill. It does an enormous amount of very important things. I'm glad to see that it has broad acceptance and agreements with some minor points of disagreement on both sides of the House. It contains many of the measures which I personally called for in my government-commissioned review of competition policy called Power to the People a little while ago, and it has definitely updated and made some much-needed changes to our competition and consumer laws. And, Mr. Deputy Speaker, however, I share some of the concerns which have already been raised today about just 4 of the amendments which have come back from their Lordship's House, which the government is seeking to oppose. And what worries me is not about the amendments themselves, because they, as we just heard from the opposition front bench, mainly seek to restore clauses which were the effective clauses which were in the bill when it came to this House originally. What worries me is that the wrong people are clapping. that the changes which the government has made, and which I think it is in many cases seeking to resist in this case, with these Lords Amendments, seem to many people to be on the side of the big tech firms rather than on the side of consumers and of competition, sharper competition and more consumer choice, and help it standing up for the man and the woman in the street. And so therefore I'm hoping, earnestly hoping, that the Minister will be able to channel his historic zeal for these things and reassure us all on several important points, if he can, in his closing remarks, in order to reassure me and I'm sure others as well, that that is not the government's intention and that they remain committed. The fire still burns brightly in his eyes in order to make this happen. I should start by saying that the government's already done some of this on, I think it is Government Amendment 38A, the Lansley Amendment, which I think they've replaced with a version of their own, which is dealing with the Secretary of State's amount of time that he or she can take in dealing with guidance put forward by the CMA to make sure it isn't unduly delayed. That I think is extremely welcome, and I would enthusiastically support that, and it is a very good and welcome measure. However, we've already heard about two other things in particular. One is the role of judicial review when it comes to dealing with penalties, and I share some concerns that in moving away from a JR standard, judicial review standard, on penalties to a full merits review, that we may get bleed across. That clever lawyers working for big tech firms may be able to effectively broaden the scope of that through clever use of legal techniques in order to make sure that they can broaden out and prolong their attempts to walk backwards slowly and prevent justice being done. I'm devoutly hoping, therefore, that my good friend the Minister is going to be able to stand up and clarify that he expects to be able to, either from the dispatch box now, or in guidance perhaps, or other kinds of clarification which he intends to issue in due course, that he will be able to show to us that it will not be possible for bleed across to happen, and that he will take any necessary steps that may be needed in order to prevent that. In fact, I think he may be about to intervene upon me now.
To make that commitment to him. We believe that the bill draws a clear distinction between infringement decisions and penalty decisions. After taking legal advice on this particular matter, look at previous competition case law considering similar issues. The government considers neither the Competition Appeals Tribunal nor the higher courts will have any trouble in making this distinction for digital markets appeals. We've clarified this in the explanatory notes, and I hope this provides that there is little risk of bleed back of the merits appeal standard from penalty appeals to appeals about other types of decisions.
Mr. Deputy Speaker, I thank him for that intervention, and thus emboldened by my success so far in getting him to Rhondda, and I thank him very much for that. Can I move on to the second point, which again has a similar kind of set of concerns around it, which is the countervailing benefits issue. Now, we've heard already from the opposition front bench about the issue here, so I won't go through and repeat it all again, but it would be enormously helpful if either now in a further intervention or in his closing remarks the Minister could be clear that the new wording, which we already had a discussion of in his initial speech, that the new wording is not intended, and that he intends to make sure, again through either clarifications now or in guidance, it is not intended to be in any way a lower standard. It is either the same or tougher than what we had before when this bill first came to the House. Now, I'm pausing just briefly to see if he wants to intervene. He does. Marvellous.
This way, if you'd like us to do that. We believe the revised wording did not change the effect of the clause. SMS firms would still have to prove that there is no other reasonable, practicable way to achieve the same benefits for consumers with less anti-competitive effect.
Well, Mr. Deputy Speaker, we seem to be making marvellous progress and actually ending up with changes being confirmed on the floor of the House in a way which I don't think I've ever seen before. So let's keep going. I'm now going to be... I'm sure this will be an equally constructive intervention, of course.
If the Minister were to say that he would change the explanatory memorandums as well.
Well, I'm sure he will grab that opportunity in his closing remarks if he so wishes, but at least he has taken the opportunity to stand up already and give us public reassurances on the record about the level of the standard which is intended, and it is no lower, I think is very, very clear. So that's an important change. Oh, and again,
we're having this debate vicariously now, but just to note that the change in wording has not changed in the explanatory notes. We've seen the two different phrases.
Mr. Deputy Speaker, I think I'm on a roll here. Final point of the four issues in question is this point about proportionality. Again, we've had the debate already, so I don't propose to repeat the concerns. Again, it would be helpful, either now or in his closing remarks, if the Minister can clarify that the new and amended standard which is being applied is no lower. I think he said something to that effect to my friend earlier on, the former Attorney General, but it would be helpful just to nail that one down and to drive the nail home at some point as well, if he can. It's important, I think, for everybody to understand whether or not that new standard is any lower at all. It should be the same or higher. He's nodding, and I don't know whether or not I can tempt him to intervene again, or whether or not he's going to wait. We will have to preserve our souls in patience, Mr. Deputy Speaker, for his closing remarks. Mr. Deputy Speaker, I'm going to therefore declare victory very shortly. I think that's been a very helpful set of interventions, and I thank the Minister for that. The final point I would make is something which is not in these amendments, but is nonetheless a commitment which he made at the dispatch box during report stage in response to an amendment which I and a great number of other parliamentary colleagues had tabled about better regulation, in which he made a commitment from the dispatch box that there would be a set of conclusions which would match a set of standards which he and I had agreed the wording on in advance, and that those would be in place before this bill receives royal assent. Clearly we are getting quite close to that date, I hope very close to that date. I understand that there may be a government white paper in the offing, but I'm not sure whether or not the government white paper is either going to arrive before royal assent, and this is not in any way intended to delay royal assent, it is intended to bring forward the white paper or whatever document the government may be thinking of. And I am also, based on conversations which I've had so far, very concerned that the commitments which were in the Minister's statement, which were made from the dispatch box in this place, may not all be in that white paper, and I therefore urge him now to make sure between now and royal assent that he is working assiduously with his fellow ministers to make sure that they have got the memo which should have come round after he made his comments from the dispatch box.
Richard Thomson.
Thank you, Mr Deputy Speaker. Scottish National Party members continue to support this bill, and we support each of the amendments that are before us today from the Lords. And notwithstanding that rather dizzying pinball rattle of interventions that went on between both front benches and the Honourable Member for Weston-super-Mare, I'm going to be a bit of a traditionalist, stick in the mud and stick to what's actually worded in the amendments and what's in the bill, and make my remarks accordingly. No matter what references might be made, I know. No matter what references might be made subsequently to debates and Hansard which had taken place, the ghosts of debates past. Now, in terms of Amendment 9, proportionate versus appropriate, and it might seem to people outside this chamber that we're dancing on something of a pinhead, but I think that distinctions like this do matter. I think it's important that decisions with the Competitions and Markets Authority should be allowed to stand wherever they deserve to stand, but that means not allowing unnecessary wriggle room to creep in for entities with very deep pockets to challenge decisions, not on the basis of the principle of those decisions, but instead on the grounds of what they consider to be proportionality. So we consider that replacing the word proportionate is appropriate in this case and would support it on that basis. Now, in terms of Amendment 13, we're debating here the inclusion or the re-inclusion of the word indispensable. Now, as the Honourable Member for Rhondda said, I think this is a term which is well understood in competition law, but it also happens, in our view, to be also proportionate and appropriate in this case, because it is entirely possible to envisage anti-competitive behaviour which can bring about consumer benefit, either as a direct or an indirect consequence. But in terms of those benefits, we're clear that they Any benefits which arise should be such that they cannot be achieved without or foregone, and that the tests should be set accordingly. In terms of 26, 28, 31 and 32, we've believed throughout the passage of the bill that the judicial review level is the appropriate appeal standard here rather than full merits, which is why we support the Lord's amendments on that basis. And finally, coming to Amendment 104 on secondary ticketing, which would introduce new requirements on that. We've heard from a number of interventions about the, frankly, astronomical, larcenous, confiscatory charges almost that are put on some tickets for certain events in the secondary market. And I think it's important to note that it's not just about the price of the ticket here. There's a considerable set of other economic choices go on round about the purchasing of a ticket. You have your travel to and from the gig, there's the other tickets that you're buying, there's the accommodation you might be having, the food and drink. It's a huge financial and emotional investment for many families to go to some of those events that are, whether they are the highest profile events that we've heard of, or whether it's something that is just of particular interest to that family or even friendship group. So I think that that's something that we should be doing our utmost to provide the best protections for people who seek to achieve these experiences that they can when they're spending their hard-earned money on this. Now, the Minister has announced a review of secondary ticketing to report apparently in 9 months' time. I won't be quite so churlish as maybe the member for Rhondda was about this. I can muster at least 2 cheers for that, although the member for Pontypridd was quite right that this government's unlikely to be in place to carry through the recommendations if it reports on that 9-month time scale. But be in no doubt, the course of action before us today that could have the greatest impact in terms of the secondary ticketing market is simply to pass the very modest, very reasonable recommendations that are before us in Amendment 104. Mr Deputy Speaker, I will draw my remarks to a close here. I will say that I hope this is the last time that we see this bill coming through this chamber. As I say, it is a bill which we support, but it is a bill which is not beyond improvement even at this late stage. And our view is it could certainly be improved were the government simply to do the right thing and accept the amendments that are before us today. Thank you.
Thank you, Mr Speaker. I just wish to speak briefly on the question I raised earlier on in the debate about the change of language from appropriate to proportionate, and follow on the remarks my honourable friend, the member for Weston-super-Mare, gave. Because at one level, what the Minister is saying now, and it's similar to what the Minister in the House of Lords, Lord Cameron, said in the debates there too, is that, well, proportionality is sort of implicit in the law anyway, that the rights that the organisation would have under Article 1 of the European Convention on Human Rights would apply anyway. And therefore, bringing this language into the bill is really a sort of tidying up exercise which really re-emphasises rights that people already have. But on the other hand, ministers also say that this change creates a better balance, which would mean that there is some change in the way this is going to work. And I think it is really important at this point that I think that we are clear, the House is clear, what it is intended from this change. And there is a concern that this opens up effectively a sort of full merits appeal basis. So something that we've been really in all the debates on this bill going through both houses keen to avoid, and I think the government has rightly resisted calls from big tech companies to bring that in, because that is a recipe for multiple and lengthy litigations, just as there is on every single measure of tech regulation that exists as a whole. That is not the intention, because if one was to say, well, is this intervention from the CMA disproportionate? Let's just say, well, yes, a company may be guilty of overcharging in an app store, but the cost of the consumer is relatively low, so would this response be proportionate to doing that? Or the overcharging in the mobile app market may exist, but ultimately, companies are happy to pay it. It's a relatively small charge, and therefore, would this big intervention by the CMA be a proportionate response or not? There are so many, if you like, competing priorities, and often the individual consumer costs that some of these measures could be quite low, but the business significance of a company self-preferencing a service to the exclusion of other companies from the market, where they might say, well, there's no consumer detriment to this particularly because the prices are relatively low, but it drives strategic market status. Now, we've already seen in the European Union with the Digital Markets Act that the companies are challenging the designation of strategic market status. They are looking for grounds to challenge at every opportunity, and we must expect they will do the same thing here as well. That's why I think it is clear that we're clear about what we mean. The member for Weston-super-Mare, I think, invited the Minister to say effectively, in terms of enforcement, in terms of how we think the courts should interpret this change, it shouldn't really make any difference from the original drafting of the language. That we shouldn't be concerned that moving from appropriate to proportionate is moving from saying the regulator should do what it's within its rights to do, it's appropriate because it has the power to do it and it's made an intervention based on that power, rather than a shift to whether, yes, even if it was appropriate for it to do it, it shouldn't have done it because it was disproportionate. And what would the grounds for that disproportionality be? And I think it is really important that in the guidance given to the legislation, that it's clear what we would expect, that how the CMA can determine and define what it believes a proportionate response is, that that's not easy to dismiss on the grounds that the cost to consumers may be relatively low or the impact is limited to a certain area of business. I will.
I'm extremely grateful for giving way, and as ever he's making a very good case, and as he knows I agree with him about the need for the government to be clear what these terms really mean. But would you also agree with me that one of the things that we are not talking about today, but which is linked to this question of definitions, is what we mean by consumer benefit? And there may be a difference between benefit to the current consumer and a benefit to the future consumer. And we should be clear in this legislation, should we not, that consumer benefit includes future consumers as well as current ones.
That's a very important point, because you could have a digital service which is provided for free, self-preference by a big company offering a new service to its customers, and how could there be a consumer detriment to that? But it could be the consequence is the constriction of the market and the driving out of business of other businesses that might exist. I think the mobile mapping market is a really good example of this, how where Google Maps and Apple Maps totally dominate a market that used to have multiple competing companies in it, now doesn't. And there could be a future consumer detriment to that too. And that's why it's important that this is an ex-ante regime, that it does anticipate not just the detriment that may exist now, but one that could be a consequence in the future. And I think this is such an important principle for digital markets, because they have tended to see the consolidation of market power in the hands of relatively small number of players, that those players often don't always compete against each other directly, but dominate certain sections of the market, be it through the mobile ad market, to search, to retail in the hands of a small number, that with app stores where there are only effectively two, which aren't, with a lack of interoperability, they're virtually monopolies as well. So we see those things already. And with the development of large language model systems and the massive acquisition of data required for AI to run them, that again is consolidating that market into the hands of largely 5 or 6 companies that have got enough data to be effective operators within it, meaning a future digital market world where really any developer, any challenger tech developer, has to access their market and their customers through the services provided by a relatively small number of companies. That's why I think it is important, and I would be grateful if the Minister could say, sort of in his winding up, when he believes that this offers a better balance, how has that balance changed? Or has it not changed? Is it a question of language and interpretation of meaning? But what actually does it mean? And what I would hope we would all agree on is, through making this change, we're not seeking to open up the legislation to a wider judicial challenge, more ruling through the courts, more lengthy delays and costs to trying to bring forward the CMA's interventions.
I rise to speak against the government motion to disagree with Lord's Amendment 104. Amendment 104, as we've already heard in this debate, seeks to safeguard fans from fraudulent abuse rife in the secondary ticketing market. And it's an important amendment on an issue that, as we've already heard, but is worth saying again, has had much work invested in it by my honourable friend, the member for Washington and Sunderland West, and her colleagues on the all-party parliamentary group on ticket abuse. It's also had great attention in the music industry, which is loud in its support for tackling ticket touting. Anyone who's tried to buy a ticket for a popular concert knows the frustrations of losing out on tickets only to see the same tickets at 10 times the price on the secondary market. But this goes deeper than mere frustrations. Ticket touting prices fans out of attending music and cultural and sports events. It damages the relationship between venue, artist and fan, and it undermines confidence in our live music industry. Yet, despite the calls of major UK music industry bodies, including UK Music and live music industry venues and entertainment, the government has consistently failed to act. Last year, the government rejected the recommendations of the Competition and Markets Authority to strengthen legislation and protect UK consumers from illegal practices in the secondary ticketing market. At the time, the Competition and Market Authorities warned that unless there was reform, illegal reselling prices would become worse. This amendment implements the recommendations of the Competition and Markets Authority to provide safeguards for consumers. These are basic protections, such as ensuring a reseller cannot sell more tickets than they can legally purchase on the primary market, and ensuring that tickets cannot be sold without proof of purchase. And I feel it's deeply disappointing that the government cannot commit to even these basic safeguards. Under their watch, the situation has become much worse. In 2007, there were an estimated 150 full-time ticket touts in the UK. Now there are around 4,000 touts attacking ticket systems for UK events using bots to harvest those tickets in bulk. Instead of being used as a resale platform for fans who can no longer make it to an event, ticketing websites are increasingly being used by large-scale touts who harvest tickets on the primary platform, using the bots to skip the queue and then sell them on at many times the price, sometimes speculatively. And ordinary fans do not stand a chance against this. It's the ordinary fans that are losing. The situation has become so bad that police forces in some areas are having to launch public awareness campaigns warning about ticket touts after hundreds of reports of ticket fraud. Lloyds Banking Group was recently forced to issue a warning to its customers about the risk of buying resold tickets after 600 of its customers reported being scammed when they tried to buy resale tickets for Taylor Swift's Eras tour. And it has been estimated that resale for the UK leg of that tour alone has led to more than £1 million being lost to fraudsters so far. And that is happening despite clear messaging from the promoters of the tour that resale tickets bought outside approved channels will be turned away on the door. As I said earlier, the government can claim that it's doing enough, and the Minister seems happy with that. But if, as I said to him earlier, if he looks again at those secondary ticketing sites and starts to see, I quoted him 3 tickets for Taylor Swift show on 21st of June going for over £72,000. That's obviously a completely malfunctioning, dysfunctional market. So he cannot claim that the market is functioning for fans and artists. It is actually functioning for touts and the platforms they use. And this amendment is just one measure to begin to counter the damage done by ticket touts, but I'm glad to say that Labour has now committed to going a step further. Labour would significantly strengthen consumer rights legislation to restrict the resale of tickets at more than a small set percentage over the price the original purchaser paid for it, including fees. Labour would limit the number of tickets individual resellers can list to the number of tickets that individuals can legitimately buy via the original platform. Labour would make platforms accountable for the accuracy of information about the tickets they list for sale, and we would ensure that the Competition and Markets Authority has the powers it needs to take swift, decisive action against platforms and touts to protect consumers. I say to the Minister, he cannot keep sticking his head in the sand over this, because as the Competition and Markets Authority warned in 2021, illegal reselling practices have become worse due to lack of action. We now get into a situation where artists and venues are on the cusp of losing the ability to sell tickets to genuine fans at an affordable price, and of course working families being priced out of seeing their favourite artist or their favourite sports team. Music and culture and sports events must not just be for the elite. People can afford thousands of pounds. So my question to the Minister is this: how can the government, how can he justify opposition to amendments which actually keep open access for fans to sport, to arts and to culture? I hope he can listen to members on this side and not push the motion to disagree with this reasonable and modest amendment.
Sharon Hodgson.
Thank you, Mr Deputy Speaker. I welcome the opportunity to speak in this debate, and it's a pleasure to follow my honourable friend who is indeed doing some great work on this as well, formulating our policy for when we hopefully are in government after the election. I'm speaking in this debate in my capacity as Chair of the All-Parliamentary Group on Ticket Abuse and to support Lord's Amendment 104, which relates to the secondary ticketing market. Before I begin, I want to reiterate that the sole purpose of this amendment is to protect British consumers from organised crime and to reduce the harm caused by the unlawful and exploitative activities of online ticket touts. Aspects of this amendment have already been recommended by the Competition and Markets Authority, who recognised back in 2021 that the UK needs stronger legislation to tackle the resale of tickets. And that wasn't just me banging on about that since, forever. This was actually the CMA calling for this themselves after looking at this market for many, many years. This amendment will not come with any cost to the UK taxpayer either, it has to be said. But if this amendment fails to become law, the only beneficiaries will be scammers, fraudsters and the overseas websites they operate from. So you're either voting in the interests of the British public or in the interests of ticket touts. And the Minister said in his opening remarks that all of us on this side, all we are doing is crowd-pleasing, and I'm sure I heard those words correctly. Well, I think you will find that the crowd all have votes, and this has been a fan-led campaign. So perhaps pleasing the crowd isn't always a bad idea. We are here to represent the people after all. Because for too long, this government has allowed an online black market for ticket resale to thrive via websites such as Viagogo, StubHub, Gigsburg, Ticombo and Seatsnet. And the public, the crowd as he called them, are sick to death of it.
My honourable friend give way.
I will.
I'm very grateful to my honourable friend, and I want to start by commending her for all the work she's done over a very long period of time on this important issue. But the reason why it's important to support the Lord's amendment in this respect is because so many of our constituents are deprived even from having a chance of getting a ticket for a sports match, for a pop concert or whatever, because they can't beat the bots. And isn't that the inherent unfairness here?
It absolutely is. It's not a level playing field at all. And I was going to come on to talk about the bots and the fact that nobody yet is behind bars for having used the bots, even though they are illegal, and even though they are the thing that they're the tool that the touts use to harvest the tickets to then scam the rest of the population and all of our constituents. You know, I'm happy to stand here and crowd please. I'll do it to my dying breath, because that is what I think we should be here to do. We should be doing the right thing for the public and what they're calling for, and they're calling for this, for us to regulate this market. I'll give way.
I don't want her dying breath yet. But did she notice that the lovely minister didn't even present a single argument against any of the individual elements in the Lord's Amendment? He didn't make an argument for why the government isn't supporting it. Even these are patently obvious and sensible measures.
And that is a very, very good observation. I would hazard a guess that probably it's because maybe the minister actually agrees with the Lord's Amendment. He's a very decent chap, and I think he will see the right in it. But of course, he's sitting on those benches, although he's always quite welcome to come and join us on these benches and do the right. It's quite a popular thing to do lately, I found. So, you know, if he wants to come over here, because we're going to actually sort this out, and it would be great if he was part of helping us to sort this all out, because I'm sure it's probably what he really deep down would like to do. So all of these websites we're talking about are based outside of the UK. They employ essentially no British staff, maybe a handful at most. It's really hard to check. All masquerade as marketplaces where fans can buy and resell from other fans. We know that's not true also. All are dominated by large-scale online touts committing criminal offences to harvest tickets in bulk, as my honourable friend has just said in his excellent intervention. This has led to a highly lucrative resale market worth hundreds of millions of pounds. This is not small fry anymore, where face value tickets are siphoned away from genuine fans and then resold back to them at highly inflated prices. My honourable friend, the Shadow Music Minister, said in her excellent speech, the number of touts has went from in the hundreds to in the many, many thousands. This is just getting out of all scale and proportion. It's best summed up also by Chris Allison, who, when he was Deputy Assistant Commissioner at the Metropolitan Police, after a 4-year investigation of touts by the Met, post the Olympics, incidentally, the tickets for which were protected in law, as I mentioned earlier, touts are part of, and I quote, touts are part of organised criminal networks often involved in other crimes, end quote. Over recent years, enforcement bodies like the CMA, National Trading Standards and the Advertising Standards Authority have tried with varying degrees of success to intervene in this broken market, either to prosecute the touts who are unlawfully defrauding music and sports lovers, or to force the ticket resale websites to comply with consumer protection legislation. And oh my, the CMA have tried to force these websites to comply, tried so hard, using the measures that they have to hand, which aren't enough. And they've even come asking for further measures, which, as we heard in the last debate we had on this, the government have rejected. It has become an increasingly complex situation to try and sort this out, which is why the Labour Party is now seeking to follow the examples of countries such as Ireland, France and Australia by capping the price at which tickets can be sold. And at this point, if I can just draw attention to my private member's bill in 2011 that sought to do just that. It would cap resale at 10% plus face value, as the Shadow Minister from the dispatch box said, to allow the extra fees, such as book and pay fees, to be reclaimed from anyone when they resell their tickets. Unlike what has been written about me over many years, I do not want to stop any fans from being able to resell their tickets when they can no longer go. I just want the scalping, the industrial scale, parasitical scalping to stop. However, until we get to that point, it is important that current legislation is made as effective as possible while the party opposite are still in government. They could do this now. These small measures wouldn't even go as far as we plan to go, but it would be a start so that we can prevent consumer harm and make it harder for the bad actors to thrive. I therefore speak in support of Amendment 104, introduced by my friend and co-chair of the Ticket Abuse All-Party Group, Lord Moynihan, with the assistance of Lord Clement Jones, Baroness Jones and others. It has to be said that Lord Moynihan is the peer that we have to thank for the amendments that help us on the Consumer Rights Act in 2015. It was Lord Moynihan who got the very small measures that we got through that we hoped would be, you know, the panacea, the moment that would solve all of what the problems we see in the secondary market. But as we know, here we are 9 years later, and the Consumer Rights Act has not fixed this broken market. This is why we need Amendment 104 as a starting position at the moment. So, subsection 1 of this amendment compelled touts to provide proof of purchase to the ticketing facility or evidence of title to the tickets offered for resale. This is common sense, pragmatic and cost-free. It only targets traders and businesses and would eliminate speculative selling, as my honourable friend spoke about in her speech, endemic to platforms like Viagogo, and the emotional devastation and physical risk that comes with it. I have seen numerous cases, as my honourable friend spoke about, where people are turned away after having travelled from one end of the country to the other at great expense, booked overnight accommodation to find they cannot get in to the theatre, the O2, the concert, whatever it may be, because they've got invalid tickets. And then sometimes, even when they get in touch prior to the event, when they fear they have an invalid ticket, like somebody wrote to me recently, they were told to try their luck on the door, regardless of the fact it was an invalid ticket. And they knew this Taylor Swift ticket would be turned away at the door. But just try your luck, and if you can't get in, we'll give you a refund. Give you a refund, you'll have to fight for it first. It might take you 6 months if you're lucky to get that refund. This person was also then told, why not sell it on? List it again, fee-free. We'll not charge you a fee to list it again. I mean, this is just outrageous. So she was supposed to pass on her, and I've got emails between her and Viagogo to back this up. She was being encouraged to sell on a ticket that she knew would be invalidated, to cause more and more victims. This is the sort of practices that these websites operate under. Furthermore, in August 2022, an ITV investigation based on data from Fanfare Alliance found that 2/3 of the festival tickets on Viagogo were being fraudulently listed by just 3 individuals. These resellers are relatively few in number, but constitute up to 90 to 95% of the tickets sold on platforms like Viagogo. So think about that, just 3 major touts selling 90 to 95% of these festival tickets. Other platforms like Gigsburg are 100% reliant on businesses and traders, many of whom My Ticket Abuse All-Party Group and the CMA believe are acting illegally. But again, no hand on the shoulder ever comes from the law. Subsection 2 would crack down on the industrial harvesting of tickets by preventing resellers from selling more tickets to an event than they can legally purchase from the primary market. That is just common sense, surely. This was first recommended by the CMA in August 2021, almost 3 years ago. They made this proposal after a 6-year enforcement investigation, concluding, as I said earlier, they needed stronger laws to tackle illegal ticket resale. This would make it easier for genuine fans to access the tickets instead of professional touts looking to make a parasitical profit. Despite it being illegal, using bots, as we said earlier by my honourable friend, and other malicious software, they do it without fear of prosecution, as no one yet has been prosecuted for using bots or for the using bots for the industrial harvesting of tickets. Artists such as Ed Sheeran, Taylor Swift have repeatedly stated they do not wish for their tickets to be touted, and the artists also get upset when their loyal fans then blame them for not protecting them from the touts, even though they do try. Taylor Swift and both Ed Sheeran have went to great lengths to try and protect their fans from the touts. Subsection 3 and 4 forces touts to clearly state the face value of any ticket listed for resale. Why, that should surely again be something that is information that should be provided. And also to provide the traders or the business name and the trading address to ensure they're clearly visible in full on the first page the ticket is viewable on, without hiding behind an icon, a drop-down menu or another device, which is what actually happens. The Consumer Rights Act states explicitly, and these are the reforms that Lord Moynihan got added to the 2015 Consumer Rights Act, states that platforms must legally provide to buyers, for example, seat locations, face value, prices and restrictions. They should be provided, and I quote, in a clear and comprehensible manner, and before the buyer is bound by the contract for the sale of the ticket. Therefore, before they purchase, consumers have a right to know what they are buying and who they are buying it from. That's in law, current law. Viagogo instead have a track record of hiding face value behind what we call hover text, or small icons, tiny with an F and a V. So you've got to know what you're looking for to find it. They obscure trader identities also behind a tiny star icon, and they only reveal a trader's identity after the user enters their credit card details and has gone through the capture purchase, the capture process. So it's often they've committed to buy it before they know who they're buying it from and what the face value is. That's in straight contravention of the 2015 Consumer Rights Act. For 99.9% of other websites, capture is used to protect consumers. On Viagogo, it's used to protect the identity of its commercial suppliers, in other words, touts. Details on ticket restrictions, for example, where resale is only allowed at face value, is provided in an unclear and incomprehensible manner, often buried in the middle of other small print and then negated by claims about Viagogo's guarantee. It's a very loose term if you're on Viagogo's website. These practices are purposely misleading for most, but even more so for those who are visually impaired, tourists who don't speak fluent English, or older people, not, without the niche technical skills, who could be buying tickets for a grandchild's birthday, for instance, which I've had lots of grandparents in touch with me. And as someone said earlier, they then feel stupid. I think it was my honourable friend. The number of emails I've had from people who say, this is my own fault, I was stupid, I should have known best, I should have checked. We shouldn't be allowing some company or companies to exist that do this in such a big way. It is not people who should be, you know, they say buyer beware. That's Viagogo's motto, I think. It's probably hidden in their website. Buyer beware. It's not right. And that's what this Parliament should be for. It's up to us to ensure that we protect consumers. We shouldn't be allowing this to happen on the scale it's happening. Furthermore, experts involved with the ticket abuse all-party group have found that large numbers of sellers are based abroad or have links to forms of organised crime, all the way up to convicted drug dealers, money launderers and bank robbers. The secondary ticket market is not full of classic entrepreneurs, as a former Chancellor and former Culture Secretary, the Right Honourable Member for Bromsgrove, would have you believe. They are serious criminals. And if you're wanting to know where you've got to look to find when he said that, it was 2011 when he was helping to talk out my private member's bill. However, convictions are extremely few and far between, despite thousands of professional touts operating, and it's important for the Minister that I clarify these numbers, as it is only 2 major cases involving 6 convictions against touts. So when I spoke of 2 cases, it's 2 cases as in, court cases, with 6 convictions. So it's not 6 cases. Just make sure that's clear on the record.
Will my honourable friend give way?
I will.
I'm very grateful to my honourable friend. I think she's making a really important point here, because she's rightly pointed out to the degree of criminality at the highest end of these organisations that are responsible for this touting industry, and the lack of prosecution. It's actually quite a good business proposition for them, isn't it? And it's relatively risk-free. You're probably more likely to get sentenced for being that international drug dealer than you are for selling the tickets.
It's very interesting that you say it came to the same conclusion I have, because in so many interviews over the years I've made that exact point and said why anybody goes out and robs banks or does any sort of crime in that way that you might get caught. Actually, you should just be a ticket out. You'll make a fortune, nobody will come after you, not even the taxman. There'll be no hand of the law on your shoulder. There's only been 2 cases, 6 prosecutions in all the time I've been doing this. So it's time we sorted this out. It's just not acceptable. The recent case that I think the Minister referred to earlier, as well as somebody else in their speech, involved individuals being convicted for buying and reselling tickets worth £6.5 million. £6.5 million.
Good grief.
Yeah, they have been caught, but that's because they're right up at the top end. There'll be people making £1 million, £500,000, £2 million, £3 million that haven't been caught. There's so many touts, and this involved, in the case I'm talking about, using multiple, often fake identities to buy large numbers of tickets with multiple credit cards. However, these convictions, as we've heard, are extremely few and far between, despite thousands of professional touts operating. Finally, those who trade in the UK must be subject to UK laws. Surely we all agree with that. Yeah. Subsection 5 states that a secondary ticketing facility must make it clear to traders and businesses based overseas that sell tickets to UK consumers and target UK consumers through paid or sponsored ads, and in some cases using Google and trusted publications, or even now I've seen sponsoring podcasts by trusted influencers and using paid infomercials, that they are all subject still to UK legislation. But the vast majority of suppliers to Viagogo and other secondary platforms are commercial businesses. A significant proportion of these are based outside of the UK, as I've said earlier, but they target UK events in order to derive as high a profit as possible. Likewise, none of these websites have offices in the UK. There are no UK jobs at stake apart from a handful, and actually it's been quite hard for me and my team to check to be sure of the numbers, as these companies are all registered in tax havens and overseas. But the damage and the exploitation occurs in the UK at the expense of artists, athletes and fans, without any fear of the current toothless UK law. Viagogo has already had its wings clipped, partially, a little bit, by the CMA orders over the years. But it's nowhere near enough, in my opinion. They have repeatedly shown that they cannot be trusted to mark their own homework. Elsewhere, for instance, Minister, Viagogo was fined $7 million Australian dollars for misleading consumers, fined €20 million for breaking the law in Italy, and €400,000 in France for breaking the law around the Rugby World Cup tickets. But here we have the Minister's colleague, it wasn't the Minister, but the Minister's colleague spouting the Viagogo lines of defence from that dispatch box just a couple of weeks ago. Go figure. And this is all on the record, as my honourable friend, the member for Worsley and Eccles South, raised it in a point of order a couple of weeks ago, just after she did it. Unless legislative action is taken to stop this black market, it will grow and continue to cause further damage. This modest amendment effectively plugs loopholes in legislation and ensures that music and sporting fans of all ages get the information they need before they make that purchase. Please, I implore everyone here today to support Amendment 104 and to start putting fans first, or else move aside so we can.
Thank you, Mr Deputy Speaker. It is an absolute privilege to follow my good friend, the Honourable Member for Washington and Sunderland West, who has been a pernicious campaigner on this issue for so many years. And I implore the government front bench to please listen to her and her expertise. Please back the amendment. A review isn't good enough, not in the dying days of a failing government, and we desperately need action now. But following that point, Mr Deputy Speaker, it is a pleasure to speak in the debate today in the consideration of Lord's amendments to the Digital Markets, Competition and Consumers Bill. Now, I proudly saw this bill through part of its common stage in my previous role as Shadow Tech and Digital Economy Minister, and it is fantastic to see it so ably sailed through this evening by my good friend and neighbour, the Right Honourable Member for the Rhondda. So I'm pleased to speak in this again today. Now, this draft legislation, as we have already heard, is woefully slow in coming forward. This is a topic that has been sat on the shelf since 2018, so it's nice to finally have it being brought back today and to see the government taking action on this. Both myself and the Labour Party more widely welcome this bill, having led the way in calling to ensure that large tech companies are under proper regulations to allow for competition in our digital markets. Now, the Labour Party have long called for measures to protect consumers, enhance innovation and promote competition in digital markets to unlock growth and level the playing field for our smaller businesses. And in the midst of a conservative cost of living crisis, this could not be more timely, and it is constantly confirmed in conversations I have with constituents in Pontypridd. But let's not forget that it has actually been a year, over a year, as we've already heard, since this legislation was first proposed in this place. Now, due to internal chaos and conflict, the Tories have long delayed this bill, and it is disappointing that it is now we are being given a watered-down version of the original bill, but that its delay is causing us to fall behind our European partners, as we have already heard. The UK has the potential to lead the way here, yet this government has instead chosen to take a back seat and be led. To say that this bill is overdue is an understatement. Since this bill was promised, we have seen the digital world continue to change, grow and expand at an incredible and exponential rate. We have seen a significant advancement in the growth of AI technology hitting the mainstream, and tech is becoming more and more central in our homes, our jobs and our social life, with our post-COVID world having adapted to hybrid, tech-dependent working styles and jobs in all sectors accommodating to this preference. Now, whether it be for work, shopping or social lives, we are all spending more time online, and I see it sadly in my own habits, amongst my colleagues, as well as from my constituents. And I believe that this is something we can all agree on. A thriving digital economy where all sectors and all businesses become digital is vital for the UK's economic growth. But despite all this, the government have failed to keep up. So now that they have decided to finally deliver this, albeit watered-down legislation, it is down to them to ensure that this legislation will survive, and if it does, to protect it from being the subject of further watered-down changes. And so far, Mr Deputy Speaker, I'm not convinced that this will be the case. While the government have provided in lieu of the First Lord's amendment that they're ignoring the remaining three, and while most of us disagree in terms of the differing semantic interpretations of the wording, it is important that we do get this wording right, so that the legislation works in practice, not just on paper. I'm afraid that these frustrations are not new. We also saw that with what is now the Online Safety Act, and much of Labour's frustrations with the Digital Markets Bill are not all that dissimilar to those my Labour colleagues and I raised back in committee stage of the Online Safety Act. Now, let us be absolutely clear. While big companies have a significant impact on our economy, this power should never be extended to our legislative process. The independence of forming legislation and scrutinising should be entirely independent from any private company interest. Parliamentarians and our government should not be influenced by any circumstances. Because we, as parliamentarians and public servants, should all be here for our people, for our constituents, not to promote and advance the interests of big companies like big tech. So what is more important to this government? Appeasing big companies or acting for the good of the exact people they are supposed to represent? And if it is not to appease big companies, why will the government not revert back to ensuring the CMA's interventions are appropriate rather than proportionate? Now, we all know that this change will have a significant impact on the scope of the big tech firms to challenge the CMA decisions under judicial review. And given that courts have to navigate these new and broader grounds for judicial review appeals of the CMA decisions, big tech firms are therefore provided with limitless legal budgets, endless pockets, huge budgets to tie up the CMA in lengthy legal disputes. It is imperative that these amendments are returned to their original form, to hold big tech firms accountable, to limit their scope to appeal and reduce the ambiguity that we've heard of today for court interpretation. Moving beyond these concerns, Mr Deputy Speaker, this bill is still absolutely needed, and that is why it has the support of the Labour Party, as do the Lord's amendments. Because we all know that the digital economy has opened new markets for businesses and has given consumers access to new information. But with rivals unable to compete with the world's most powerful global companies, they do not sit on equal footing. Google has more than 90% share of the 7.3 billion search advertising market in the UK. And Facebook has over 50% of the £5.5 billion display advertising market. That is completely unfair and is both a challenge to businesses and a detriment to consumers. This means that the everyday consumer has little to no autonomy over their online choices, as well as how much data they have to give out. And as for businesses, this is limiting their innovation, as their ideas are likely to be quashed by an algorithm, and therefore they are unable to compete by any reasonable and fair means. For example, Amazon, using their position as both a marketplace, a publisher and a bookseller, has been detrimental to the potential and work of independent booksellers who are pushed to the side due to them not being able to compete with these huge companies and the advantages that the marketplace affords them. I'm so glad to see that the Lord's Amendment recognise this importance of user choice, autonomy and independence from these big companies, pushing an agenda onto them and escaping scrutiny. So why then has the government shied away from this? And if this is the case, as the government claims, that the wording maintains the same high threshold, why will the government simply not clarify that the indispensable standard and the new standard are equal? What exactly is the government afraid of here? Big tech must be held accountable and not be able to complicate legal proceedings and escape scrutiny. Surely this is a point that should not cause a disagreement. So if not, then why has the government again moved to a merits appeals approach to penalty decisions? This is completely unworkable. Proceedings must take a judicial review approach. This will judge a decision on its lawfulness rather than its correctness or based on the views of a tribunal. Such an approach will fail to incentivise big tech firms to comply with the CMA decisions. And while the Tories' watering down of this legislation and its wording may initially appear trivial, in fact, this will only encourage big tech to challenge the decisions of the CMA. If we want this legislation to actually be workable, to be worth the paper it is written on, we must ensure it is clear, it is precise and it is unambiguous. And with the concerns that the judicial review and merits elements of appeals could bleed into one another, ambiguity is already rife in this bill. The government must reverse its watering down of this all-important legislation, or at the very least simply clarify exactly what the changes in this wording do represent. And this reason is exactly why all four of the Lord's amendments are so necessary. I urge the government to reconsider them with the seriousness that they deserve and, at the minimum, make efforts to compromise as they have done on the first amendment. The same must be done on the other three. These changes would bring small businesses onto a level playing field and protect the autonomy and pockets of our consumers. If this legislation fails to do that, if it is watered down any further, it will not be worth the paper it is written on. The government can do the right thing here, and they should take the opportunity to do so, and I implore them to do so. Thank you, Mr Deputy Speaker.
I'm very grateful, Mr Deputy Speaker.
Today I want to speak in support of Lord's Amendments 104 and the Lord's Amendments relating to foreign state ownership of UK newspapers, and I'll raise some of the questions about the Lord's Amendments relating to consumer protections against unfair subscription practices and the use of fake reviews. I want to start by setting out my overall support for the bill and to establish a bit of context for why it's so important to get the regulation of the digital economy right. Because over the past decade, our economy has obviously been transformed by digital change. In many ways, this has brought benefits, but equally new harms, new ways that unscrupulous individuals and companies can exploit us all. People in our communities are affected by failures of existing digital regulation, and I would argue that it's often communities like mine that bear the brunt. Because in Newham we have significant digital exclusion, and there's been massive damage to family finances by cost of living costs. It's all the more damaging to be ripped off when your income barely manages to pay the bills already. And it's more than that, because in times of stress and when people are working long hours to make ends meet, they hardly have the time or the energy to read through often opaque terms and conditions before purchasing. They are less likely to have the capacity to go searching past all the deliberate barriers that could be set up to find out how to cancel a subscription that's costing them dear. I have to say that even with assistance from younger members of my family, I personally have failed to cancel a number of subscriptions that I was absolutely assured had gone. So we have to get this right, if not for me, but for others, to have the capacity to go searching past all the deliberate barriers that can be set up to find out how to cancel those subscriptions. This bill and many of the Lord's Amendments do make welcome progress on some of these issues. So I'm going to start with ticket touting, which, as we know, is one of the most egregiously exploitative practices that we see. I think we can agree across this House that it is simply wrong to buy tickets in bulk and then charge a huge markup fee for resale. It causes massive barriers to accessing culture, particularly for people on lower incomes, and the revenues go not to our hard-pressed musicians and venues, but to grifters who add absolutely no value of their own. I will give way.
I'm very grateful, and it comes back to the point of the bots, because even the most tech-savvy person cannot beat the bots. And once they set those bots going, they sweep away all the tickets and genuine fans can't get it. And that is so unfair, almost as unfair as the extortionate prices these companies then charge for the tickets they've swept up with the bots.
Yeah. I mean, my friend is absolutely right. I mean, we have families struggling to buy tickets for their children who are desperate to go and see X band or Y band, and then they find themselves ripped off without, well, I don't know what the latest bands are, ripped off and unable to attend to have that treat that was so massively looked forward to. So I want to pay a really huge credit to my honourable friend, the member for Washington and Sunderland West, for her years of dedicated campaigning on this. Her work has helped to bring this issue to the forefront of debate and make clear that legal change is necessary to protect our cultural industries and the consumers from the touts. On this side of the House, we have a clear policy to stamp out ticket touting, because opposition policy would mean that no one will be able to charge a large markup on resold tickets. I will.
I'm grateful, and isn't it important to emphasise that this does need legislation, because lots of venues have tried their level best to get this right. So, for instance, the O2 Arena, they only endorse the use of their reseller, AXS, which is only allowed to sell tickets to 10% above the original price, which is precisely what we're saying should be available to everybody else. But they can't stop all the other companies effectively nicking all these tickets because of the use of the bots. That's why you need legislation.
I absolutely agree with my honourable friend. We have tried to nip this in the bud by bringing it to the public's attention, by trying to put pressure on individuals and to encourage action to be taken. We need legislation to stamp it out. I like the fact that in the legislation proposed by this side, there will be an upper limit on the number of tickets that an individual can resell to make organised ticket touting an unprofitable practice. People who honestly buy tickets and then find that they can't attend should absolutely be allowed to sell their tickets on. And that's in the consumer's interest. That is in the best interest of our constituents. But culture and sports fans should no longer be gouged and exploited. Yeah. And thankfully, there's an amendment before us today that would do this very thing, put forward by no other than the Conservative noble lord, the Lord Moynihan, that would go some way to implement these protections. But despite this, the government seems determined to oppose change and go no further in protecting consumers from ticket touts, even though they acknowledge the problem persists. Frankly, I know that my constituents would want to understand why the government appears determined to stand in the way of greater protections, even when they're being put forward by one of their very own noble lords. Why are the government ignoring the voices of fan organisations and creatives who want a fair, properly regulated market in event tickets? Yeah. I think that the Minister might have a job of work to do, convincing my constituents that this is about sound regulation, rather than the failed free market ideology of the former Prime Minister, the member for South West Norfolk. In this House, we must not forget the importance of protecting Britons from unfair practices, and we must always remember to put them first. And we know that this is far from the only area where poor regulation of our cultural and media markets poses serious risks to consumers and communities alike. So I want to say a few words about the large number of amendments put forward on state ownership of our newspaper. I want to thank the opposition frontbench colleagues for demonstrating leadership and pressing action on this issue, and I want to welcome the government's amendments in the other place following those calls. It's important that now there's something like a cross-party consensus on this, because we do live in a world where distrust is stronger and misinformation absolutely thrives. I know many of us share the fear that genuine, honest journalism is becoming a rare commodity. Yeah. And the impacts of that are massive right across our society. Failure to promote a trustworthy media landscape fuels conspiracy theories, and it fuels extremism, and it distracts attention from the genuine, massive challenges that face us as a country and as a world. We should all fear becoming a society that is riven by division, because all of our communities lose out from that. I believe that only scammers, extremists and tyrants ultimately benefit. And I'm not saying that foreign state ownership of UK newspapers would lead directly to those media outlets spewing division, hate and lies, but I am seriously worried about the further impact it would have on public trust in our media. And we all need to recognise the greater potential for interference in our democracy from foreign states if they own media outlets directly. I believe we can't just act to block foreign state takeovers of paper. I think our agendas need to be wider than that. I think we need to support impartial and independent public interest journalism through the BBC, including the fabulous World Service, which is so important and currently in significant financial difficulty. We need, obviously, to continue acting to improve regulation of online social media spaces where, as we know, trust is near extinct and where so much harm is done to the most vulnerable in our communities. So amendments against foreign ownership of newspapers are only a tiny part of the solution, but they are a step forward. So I want to welcome the action taken in the other place on this issue, which has improved this bill. And finally, I want to speak to some of the wider amendments that have been made in the other place to better protect consumers from scams and exploitation. As we know, the abuse of subscription services by hiding away cancellation options is something that affects people in every part of our country. People are losing money steadily month after month for services they don't want but don't know how to cancel. Citizen Advice estimate that £300 million a year is being spent on unwanted subscriptions. Obviously, that's even of more concern where people aren't completely digitally literate. So I'm hoping that the Minister might, in winding up today, tell us more about what work is being done to monitor progress with and to update the digital inclusion strategy.
Hear, hear.
Because I think it is a bit of a shock that there's been no update, I understand, for about 10 years now. And according to Age UK, nearly 6 million older people cannot use the internet. And this affects many of my constituents. Just one example came from a constituent who recently told me about how they missed a hospital appointment because they lost the message telling them about it. And we all know that this is just too common in communities, and it creates unnecessary and unfair barriers to accessing so many of our public services and just, basically taking part in everyday life. So frankly, anybody can be impacted based on some of the examples I've seen, but because many attempts to make it massively harder to cancel a subscription agreement than it is to enter it are just blatant. They're egregious, and it is difficult for any of us to navigate around. Additional protections in law simply can't come soon enough. So clearly, there's widespread recognition that greater clarity is needed in the regulation. And regulators will obviously need to be more active in holding the providers of subscription services to account where they use exploitative tactics against consumers. The test for this bill is whether it will deliver that. So I welcome the debate that was had in the other place on details of how this is implemented in law. And slightly unusually, I want to give credit to the noble lord, the Minister, in the other place, for rightfully engaging with probing amendments, but also seeking to maintain stronger protections for consumers. But I hope the Minister, again, will say more in summing up about where the bill ultimately stands. Will the regulator have the clarity and confidence they need to start enforcing against exploitative practices? Or are we going to be back here again in a few years after the regulations have been tested and found sadly wanting? And I'd argue that the lack of clear prohibition on creating fake reviews was clearly an omission from this bill in its initial form. Greater clarity on this has been called for by my front bench opposition colleagues from the second reading onwards almost a year ago now. So I absolutely want to welcome measures that have now been included, because in everyday lives, when we're looking for goods and services online, many of us have little alternative but to rely on reviews. Faking reviews is clearly a massive threat 2, genuine competition. It's effectively an open door for scammers and cowboys to rip off people further. And again, I'm hoping the Minister might say a little more on this in summing up about the final position that we've got to. There was a significant debate in the other place through probing amendments, which questioned whether stronger provisions were needed, particularly on the responsibilities of platforms and internet service providers who can play host to fake reviews. So is the Minister absolutely confident that these platforms are clear about the actions that they must take to stop their services being abused by fake review scammers? Mr. Deputy Speaker, I'm not entirely happy with everything in this bill. I remain seriously disappointed that the government's inaction on ticking touting, and I hope again that the Minister will look and maybe find it within his heart to support Amendment 104. And I want to echo many of the comments of my honourable friend, the member for Rhondda, about some of the ways that the general enforcement and appeals provision in the bill have been weakened. Clearly, I fear, there's been some heavy lobbying of the government by big tech companies, which has had an impact. I do not think that people of West Ham will be pleased to hear that. It generates understandable concern that the provision in this bill might prove too weak and too riven with loopholes to actually do the job that I believe both sides of the House genuinely want to see. But in other areas, the bill has been improved, thanks to honourable friends and colleagues, both in this and the other place. It contains welcome provisions that will help to protect my constituents from exploitation online. And I hope we'll see it in force as soon as possible.
Very much. Minister?
Thank you, Mr. Deputy Speaker. And with the leave of the House, I'd like to respond to some of the points raised in this very fruitful debate with some very constructive remarks from members. I'll start with the Shadow Minister's points. Can I just reassure him I've lost none of my mojo or my ambition in terms of wanting to make sure we have a fair and level playing field for businesses. Absolutely vital part of this legislation. Yes, I have. At times I might smile when I'm at this dispatch box. A couple of reasons. I'm generally a happy guy, I think, but also I'm very pleased to see this groundbreaking legislation being brought into effect. And I think it's only probably one of two major pieces of legislation around the world that does what this does. So I think we should welcome that and say the fair and level playing field that will result from this legislation. I think he says he seems to think we have caved in certain areas and weakened some of the provisions of this bill. I don't accept that. I think it's very fair to say some of the platforms would like us to have changed this bill radically from where it was presented to Parliament. We think we've very much held the line in terms of its provisions and how it will make sure that those consumers and smaller businesses get a better deal. We don't accept that this be the bleed back, as he puts it, between the on the merits, provisions of penalties compared to other regulatory decisions. We've been very clear on that, and our legal advice is of the same mind. On secondary ticketing, obviously a key part of the debate from various different members. Clearly, we absolutely see that there is some good practice in some of the primary markets where there is control about resales, and we should learn from best practice. Things like ID requirements, for example, on resale of tickets, and that's within the gift of primary markets. So we're keen to develop this review to make sure we look at the primary markets and the secondary markets as they wanted in their amendments at an earlier stage in the progress of this bill through the House. I'm very happy to give way, of course.
I'm very grateful.
To the Cheshire Cat. Why does he oppose the amendment on ticket touts from the Lords? Is it the clause that says that there must be proof of purchase for the secondary ticket marketing, or is it that they have to provide details of the face value of the ticket? Why is he opposing the amendment? It's very difficult to determine, other than some sort of inconvenience to government.
Oh, we believe that those measures are already covered, such as the face value of tickets and current legislation and enforcement. I mean, this government has gone further, certainly a lot further than previous regimes have done this in terms of strengthening terms and guidance. That was in 2017, in banning ticketing bots, which he referred to. He didn't seem to understand this had been outlawed in 2018, and indeed improving enforcement action by the regulators. There have now been 6 successful prosecutions under this new regime. Can I just remind him where other jurisdictions have gone further, supposedly, in banning resale tickets? There have been no prosecutions in Ireland, for example. So what we're trying to do is make sure we have a balance, make sure that the provisions we have work well. I will come to the Honourable Lady in a second in terms of her points. Very keen to respond to some of the points she makes in this particular space. Happy to go there.
But I just wonder, if he goes to a Viagogo website and tries to buy a ticket, can he see on there at the first page, when he's buying the ticket and it says it's £420 or whatever, can he see on that page how much the price, the original value was? No. Can he see whether it's a validly purchased ticket? No. That's the problem that this amendment would solve. It will be very, very simple for the government simply to agree it, and then we could get the bill through.
Well, we believe those provisions are already there. I've used Viagogo on many occasions, quite happily, and other people have too, in terms of being able to resale those tickets. Of course, we'll keep looking at this. We're looking at the primary markets and the secondary markets, and indeed the interaction between the two different markets. And we think that's a right thing to do in terms of making sure we develop the right way to regulate this, so we can do that in a future Parliament. My honourable friend, I will come to the lady's points in a second if I can. My right honourable friend, the member, the member for Weston-super-Mare, I can assure him also the fire burns brightly in me in terms of many of the things we're trying to do to hold that big tech to account, and I don't think we've moved it in any material way in terms of making sure this legislation is fit for purpose and does what it's set out to do. As I said earlier to him in his intervention, we don't believe there's any bleed across between the penalties, the on the merits approach to penalties compared to other regulatory interventions. The countervailing benefits, the revised wording, did not change the effect of the clause and indeed did not change the guidance in the explanatory notes. Much work we're doing on regulation, as he's aware, and we've engaged on regular occasions in terms of making sure that gets to where he wants to get to, in things like costs and benefits. He'll have noticed we brought forward the growth duty for our economic regulators quite recently, the Smart Data Roadmap, and I know it's with bated breath for the white paper that will come forward shortly. And the Honourable Member for Gordon, can I thank him for his support for the legislation? We don't think the change from conduct is indispensable to the benefits. Benefits could not be realised without the conduct, materially changes the position in any way. My own friend, the member for Folkestone and Hythe, talks about we've moved to a different balance. I don't think that I said that, and I'm sorry for clarifying my remarks in terms of proportionality. I just think we've provided more certainty, more clarity around that particular position, which we always thought was part of the way that CMA would make its decisions. In terms of his points he makes, how would a regulator view, for example, the probably quite significant charges being made across the app platforms, both charging 30% to the people who have e-commerce through those payment systems. As he knows and I knows, I think he said businesses might not think that's too much. As he knows and I knows, it's not businesses that pay that ultimately, it is consumers. And the requirement for the CMA to make interventions that are in the benefit of consumers is in their very DNA. So I think they would act in those kind of situations. The Honourable Lady for Worsley and Eccles talks about the secondary ticketing position. I hear very clearly her points and the points raised by the Honourable Member, the Honourable Lady, the Member for Washington and Sunderland West. I'm happy to take an intervention.
I wanted to counsel the Minister against what he's doing, which his colleague in the DCMS team did recently, oral questions, which is actually repeating the arguments that the platforms use. A global chief officer of Viagogo was over here, and it's sad to hear ministers repeating things which the same sort of lines that officer was coming out with. In Ireland, fraud activity has not increased. The legislation is working in Ireland. There aren't prosecutions in Ireland because it's working. We would be in that situation. And as my friend probably wants to point out, it's all right to say that the use of bots is illegal. Nobody's being prosecuted for this illegal use of bots to wholesale buy tickets. It's happening. So I really do want to counsel the Minister against this constant repetition that he and his colleague ministers are coming up with, because it's not plausible to anybody outside.
Well, she's right to say there's a difference between legislation and enforcement. Of course there is, and we would urge the authorities that have the responsibility to enforce those provisions to make use of them. In Ireland, where they ban the resale of tickets, inflated prices are still a feature of their ticket markets. There are Taylor Swift's Dublin shows selling well in excess of the face price on the internet there, so they're and they said no prosecutions have been made. As I said to her in my earlier remarks, and I'll say to the Honourable Lady, the member for, if I can just say, I said before she intervenes, for Washington and Sunderland West, I wasn't accusing her of crowd pleasing. Can I just put that clear? I was saying what we shouldn't do is simply take measures that are crowd pleasing in the hope they would work, but they are ineffective. That's not to say. It's not to say we don't think further measures are required. Very happy to take her point.
Thank you so much. On the point about Taylor Swift and any of her tickets being the secondary market in Ireland, I would challenge him to go back and not just sort of take the word from his officials if he's got that from them or whoever has told him that, because I've been told that none of the you can find no Taylor Swift tickets on Viagogo in Northern Ireland because her tickets, she has stated they're not valid if they're resold on a secondary platform. So you won't find them on a secondary platform in Ireland, not Northern Ireland, Ireland.
Yes, it's Ireland we were talking about. I've just Googled, actually, Taylor Swift tickets in Dublin, and you can buy tickets well in excess of face value on the platform. I agree, I couldn't find any on Viagogo, but other platforms are selling those tickets. So what we're trying to do is do something that is effective. I'm very happy to continue to engage with her. I've heard very clearly the points she's made, and she makes a very compelling case. Continue to look at that and continue to engage with her. I'm very keen to make sure we do get in the right place that protects consumers but allows a free market where it is fair to work properly. Happy to give way.
To the Minister for giving way. I just want to take him back to the point he was saying about new legislation not being needed, but better enforcement needed. So the enforcement authorities would be trading standards, presumably. I just wonder from the Minister's perspective if the reason why there aren't the prosecutions that we would all like to see, A, because trading standards have been run into the ground and they do not have the capacity to do the job he's expecting, but also the complexity of this market. Because which trading standards is responsible? Is it the trading standards for where the platforms are based? Is it the trading standards for where the person who bought the ticket is based? Is it the trading standards for where the concert is being held? Makes it really, really difficult to enforce.
It does, that's exactly the point.
Well, I can thank him for his points. I didn't say legislation wasn't needed. I said there's no point in having legislation without enforcement. That's what I actually said. There have been 6 successful prosecution by trading standards. If he wants to fund trading standards to a greater degree, obviously I understand there's some pressure on local authorities across the country. There are pressures on the public finances generally. Now, if he's got a solution to that, where he's going to provide lots more money to local authorities, perhaps he should have a word with his front bench, because that's not been policy. But if I can just conclude with the last... I'll just take this intervention here. This young lady wanted to intervene.
Like with the trading standards, a lot of cash-strapped families and young people fall for online scams because they're on the hunt for bargains on Facebook Marketplace and to the lesser extent eBay and Vinted. They're often at the mercy of being ripped off with very little protection and little to no help from local trading standards, because there's that confusion about whether it's where the buyer is, where the seller is, and particularly because they're for more casual and lower value transactions. I was wondering if the Minister could confirm whether this would be within the review as well.
Well, can I thank the Honourable Lady for her intervention. She makes a very good point. Very happy to look at the concerns she raises, and we will look at all concerns raised by all stakeholders, members of this House and further afield, to make sure when we do this review we get to the right place. The Honourable Lady, member for Pontypridd, she talks about the EU, the legislation in the EU, seems to think it's stronger than ours. Just point out that in terms of the appeal standards consider the merits across the piece in the European Union. They do not in the UK. They're confined to a very small element of it. And finally, the Honourable Lady, the member for West Ham, pleased she supports the bill. Very pleased she supports freedom of speech. Digital inclusion, very important. My honourable friend here is working very hard on social inclusion, social tariffs, a broadband, for example, through the Cost Ministerial Group, and we are very keen to make sure reminder notices for subscriptions are very clear for all our consumers. So if I can conclude, Mr Deputy Speaker, I urge all members on both sides of the House to carefully consider the amendment that I propose today in lieu of those made in the other place. I hope all members will feel able to support our position, and I beg to move.
Thank you very much. Taylor Swift does seem to be everywhere, doesn't she? Even in the House of Commons. So here we go. I'm expecting several votes. The question is that this House disagrees with the Lords in their Amendment 9. As many of that have been say aye. Aye. The contrary, no? No! Division, clear the lobby. Order. The question is that this House disagrees with the Lords in their Amendment 9. Has many other say aye? Aye. Contrary, no? No. Tell us for the ayes, Mark Jenkinson, Robert Logan. Tell us for the noes, Jeff Smith, Colleen Fletcher. Order. Order.
The ayes to the right, 273. The noes to the left, 159.
Thank you. The ayes to the right, 273. The noes to the left, 159. So the ayes have it. The ayes have it. Unlock. We now come to the motion to disagree with Lord's Amendment 12. I call the Minister to move the motion. The question is that the House disagrees with the Lords in their Amendment 12. As many of that opinion say aye. Aye. Of the contrary, no. No! Division, clear the lobby. 8. Order. The question is that this House disagrees with the Lords in their Amendment 12. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Mark Jenkinson, Robert Largan. Tell us for the noes, Jeff Smith, Colleen Fletcher. Order. Order.
The ayes to the right were 276. The noes to the left, 161.
The ayes to the right, 276. The noes to the left, 161. So the ayes have it. The ayes have it. Unlock. We now come to the motion to disagree with the Lords. Amendment 13. I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 13. Is Madam say aye? Aye. No. I think the ayes have it. The ayes have it. We now come to the motion to disagree with Lords Amendment 19. I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 19. Is Madam say aye? Aye. No. I think the ayes have it. The ayes have it. We now come to the motion to disagree with Lords Amendment 26. I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 26. As many of that opinion say aye. Aye. Of the contrary, no. No. Vision. Clear the lobby. Order. Order. The question is that this House disagrees with the Lords in their Amendment 26. As many as are of that opinion say aye. Aye. Or the contrary, no. No. Tell us for the ayes. Mark Jenkinson, Robert Largan. Tell us for the noes. Colin Fletcher, Jeff Smith. Order. Order.
The ayes to the right, 274. The noes to the left, 162.
Thank you. The ayes to the right, 274. The noes to the left, 162. So the ayes have it. The ayes have it. Unlock. Thank you. We now come to the motion to disagree with Lord's Amendment 27. I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 27. Does that opinion say aye? Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to motion to disagree with Lord's Amendment 28, and I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 28. Does many of that opinion say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to the motion to disagree with Lord's Amendment 31, and I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 31. Does many of that opinion say aye? Aye. Of the contrary, no. No! Vision, clear the lobby. Order. Order. The question is that this House disagrees with the Lords in their Amendment 31. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Robert Larg and Mark Jenkinson. Tell us for the noes, Colleen Fletcher, Jeff Smith. Order. Order.
The ayes to the right, 272. The noes to the left were 162.
We've got one more.
Thank you. The ayes to the right, 272. The noes to the left, 162. So the ayes have it. The ayes have it. Unlock. We now come to motion to disagree with Lord's Amendment 32. I call the Minister to move the motion. The question is that the House disagrees with the Lords in their Amendment 32. As many of them say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to motion to disagree with the Lords Amendment 38. And I call the Minister to move the motion. The question is that this House disagrees with the Lords in their Amendment 38. As many of them say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government Amendment A in lieu of Lord's Amendment 38. Minister to move formally. The question is that the Government Amendment A be made in lieu of Lord's Amendment 38. As many of them say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to motion to disagree with Lord's Amendment 104. Call the Minister to move the motion. The question is that the House disagrees with the Lords in their Amendment 104. As many of them say aye? Aye. Of the contrary, no. No! Vision, clear the lobby. Order. The question is that the House disagrees with the Lords in their Amendment 104. As many of them say aye? Aye. Of the contrary, no. No. Tell us for the ayes, Robert Largan, Mark Jenkinson. Tell us for the noes, Colin Fletcher and Jeff Smith.
Oh, that was a bold name.
Order. Order.
The ayes to the right, 273. The noes to the left, 163.
Thank you. The ayes to the right, 273. The noes to the left, 163. So the ayes have it. The ayes have it. Unlock. The leave of the House, I call the Minister to move that the House agrees with the Lords in their amendments 1 to 8, 10, 11, 14 to 18, 20 to 25, 29, 30, 33 to 37, 39 to 103, and 105 to 148. The question is that this House agrees with the Lords in their amendments 1 to 8, 10, 11, 14 to 18, 20 to 25, 29, 30, 33 to 37, 39 to 103, and 105 to 148. Does Mayor Dunlop say aye? Aye! Contrary, no. I think the ayes have it. The ayes have it. Minister to move that a committee be appointed to draw up reasons.
I beg to move that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to certain of their amendments, that Kevin Hollinrake, Sir Keith Batty, Mike Wood, Steve Tuckwell, Chris Bryant, Colleen Fletcher and Richard Thomson be members of the committee, that Kevin Hollinrake be the chair of the committee, that 3 be the quorum of the committee, and that the committee do withdraw immediately.
The question is that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to their amendments 9, 12, 13, 19, 26, 27, 28, 31, 32 and 104. That Kevin Hollinrake, Sir Keith Batty, Mike Wood, Steve Tuckwell, Sir Chris Bryant, Colleen Fletcher and Richard Thomson be members of the committee. That Kevin Hollinrake be the chair of the committee. That 3 be the quorum of the committee and that the committee do withdraw immediately. As many of them say aye? Aye. We know. I think the ayes have it. The ayes have it. And that concludes consideration of Lord's amendments to the Digital Markets, Competition and Consumers Bill. We now come to motion number 4 on local government. Minister to move.
I beg to move.
Question is as on the order papers. May I say aye?
Aye.
No, I think the ayes have it. The ayes have it. We now come to motion number 5 on electricity. Minister to move.
I beg to move.
Question is as on the order papers. May I say aye?
Aye.
No, I think the ayes have it. The ayes have it. We now come to motion number 6 on road traffic. Minister to move.
I beg to move.
Question is as on the order papers. May I say aye?
Aye.
No, I think the ayes have it. The ayes have it. We now come to motion number 7 relating to education. And Sir Bill Wiggin is moving into his place. So we call... Should we start again? Yeah, no, we'll start again. We now come to motion number 7 relating to education. Sir Bill Wiggin.
I beg to move.
The question is, as on the order papers, may I say aye? Aye. No, I think the ayes have it. The ayes have it. We now come to motion number 8 relating to European Scrutiny Committee. Sir Bill Wiggin.
Beg to move.
Question is, as on the order papers, may I say aye? Aye. No, I think the ayes have it. The ayes have it. We now come to motion number 9 relating to justice. Sir Bill Wiggin.
Move.
The question is, as on the order papers, may I say aye? Aye. No, I think the ayes have it. The ayes.